Good morning, ladies and gentlemen who are present and of the media and the public members. Thank you for joining my fellow commissioners and me for the commencement of this Commission of Inquiry hearing. I am retired Justice Norma Wade Miller. I was appointed by the Honorable Premier, the Honorable E. David Burt, JP, MP, as Chair of the Commission of Inquiry into historic losses of land in Bermuda. Serving with me as fellow members of the Commission are the Honorable Wayne Perrin-Chief, a former Minister of National Security and retired Assistant Commissioner of Police, Mrs. Maxine Binns, former Consultant Legal Counsel with the Business Development Unit and retired Legislative Assistant with the Business Development Unit, Mrs. Frederica Fort, a former banking senior bank manager and an experienced realtor, Mrs. Linda Milligan White, senior legal counsel practicing at the Bermuda Bar, Mr. Jonathan Starling, economic and cooperative development officer with the Bermuda Economic Development Corporation, and Mr. Quinton Stubble, a prominent quality surveyor. Permanent Secretary Ms. Marva O'Brien was statutorily appointed clerk to the Commission. The Commission's Secretariat provides administrative and other support to the Commission. The members are Mrs. Alberta Dyer Tucker, a retired senior civil servant, and Mrs. Alicia Lister. The Commission is well served by counsel, Queen's Counsel Mr. Ivan Whitehall of Canada, who was selected by the chair of the Commission to carry out the responsibilities of counsel to the Commission. The pandemic makes it impossible for Mr. Whitehall to travel to attend this hearing in person. However, I am glad to advise that thanks to modern technology, we're able to link with him electronically for the purpose of this hearing. I will say just a few words about Mr. Whitehall, although time will not allow me to speak of his many professional accomplishments. However, I will offer a snapshot of his background. In 1989, Mr. Whitehall became the Chief General Counsel of the Department of Justice, occupying the senior litigation position of the Government of Canada with the rank of Assistant Deputy Minister. He was in the position until he retired from the public service in 2003, when he became counsel to a major national law firm. He has extensive experience serving as counsel on various commission of inquiries. Mr. Bruce Swan, local barrister and attorney, is junior counsel to Mr. Whitehall and will lead aspects of the examinations during the hearings. Having introduced our team, I would like to move on to the matters which may be considered by the Commission, as those matters are limited by the order. It is important to clarify that the mandate of the Commission is not to resolve disputes between parties or to make any legally binding order for the return of the properties that are alleged to have been wrongfully taken. It should always be made clear that whereas this body has been politically conceived and appointed, it has quasi-judicial functions. It is incumbent upon us to be thorough in our examination of the evidence, objective in our assessment of the facts, and impartial in our findings. We are mindful that these tasks are one of historical significance and may ultimately be put to the test of judicial scrutiny. I take this opportunity to personally thank each commissioner and council, Whitehall, who all diligently met on a weekly basis and sometimes twice weekly via Zoom during the shelter-in-place regime. I would also like to thank them for their patience with me while I learned up the technology of the new Zoom era. The year 2020 is one of significance to the entire Bermuda community. Therefore, it is perhaps fitting that the Commission is involved in its deliberations this year, as the 6th day of August 2020 marked the 100th year anniversary Tuckerstown's expropriation that allowed for dispossession of property. That having been said, I now invite your close attention as I enunciate the Commission of Inquiry's mandate. The scope of the inquiry is specifically to inquire into historical losses of citizens' property in Bermuda through theft of property, dispossession of property, adverse possession claims, and or such other unlawful or irregular means by which land was lost in Bermuda. Collect and collate any and all evidence and information available relating to the nature and extent of such historic losses of citizens' property. Prepare a list of all land to which such historic losses relate. Identify any persons, whether individual or bodies corporate, responsible for such historic losses of citizens' property. The Commission may also refer, as appropriate, matters to the Director of Public Prosecutions for such further action as may be determined necessary by that office. While allegations have been made about historical land grabs, it is the responsibility of the Commission to determine what the evidence substantiates. This has been done in a systematic manner, utilizing a rigor befitting of the gravity of the task. I will not at this stage provide the exhaustive listing of the grievances. Suffice to say, when we consider the allegations dealing with applications for standing before the Commission, all of the applications with respect to Tuckerstown and St. David's expropriations will be considered. I see my commissioner to my left realized that I need a little sip of water. I crave your indulgence, please. Thank you for that indulgence. We have also considered more than 50 other complaints that we have received. Of that number, the commissioners have determined that over 25 fell within our mandate. We invite the public to take note of our deliberations with the keenness of interest warranted by the gravity of these events. A word about our original plan. Although we had high hopes and many good intentions, we found ourselves in the unfortunate position of having to change our starting date several times. We had originally intended to start these hearings on the 24th of August, which changed to the 3rd of September, and ultimately here we are today. Again, as part of our original plan, and in order to provide a solid foundation as an underpinning to our inquiry, we were hoping to begin our deliberations with the reports from two well-known local historians, Dr. Quito Swan and Dr. Theodore Francis. However, due to the COVID-19 pandemic and the concomitant closure of archives and other government organizations in the United Kingdom, United States, and Bermuda, our historians have experienced an unavoidable delay as they have sought the materials required to support their findings. As a result, they are not ready to begin today, but they have undertaken to be our first two witnesses commencing on the 19th of October, 2020. We definitely look with great anticipation to hearing their testimony. In order to do justice to the matters which have been brought before us, the Commission engaged a small team of investigators led by retired police officer Mr. Carlton Adams. However, due again in part to restrictions imposed by the pandemic, our team of investigators are not as advanced as we would have hoped. However, we look forward to reviewing their evidence and to hearing what they have found by the second tranche of the hearing, which begin in October. Regrettably, this, coupled with the unavailability of other key witnesses, has forced us to shorten this tranche of our hearings. Before I end, please allow me to make what I would like to call a public service appeal. In order to ensure that we properly deal with as many of our cases as possible prior to our October hearing, I would like to invite any retired police officer who is willing to volunteer his or her service to come forward to assist us. The investigation process is not complicated, as our chief investigator, Mr. Carlton Adams, will avow. Any retired officer who is able to assist should contact the Commission office on the 4th floor of Sophia House, 48 Church Street, Hamilton, or contact 535-9801. What could be better than to give the gift of helping our community heal? Mm-hmm. I close by referring to a few words of encouragement from the Right Reverend Nicholas Still, the Anglican Bishop of Bermuda, who recently wrote to me. I quote from the Bishop: "I hope your work allows truth and light to float to the surface, enabling us to move forward as a community. May God grant you and your team wisdom, patience, and courage." Before our work commences, and I call our witness, I now invite the Commission Counsel, Mr. Ivan Whitehall, to address you. Thank you.
Thank you, Madam Chair and the Commission. Before commencing my more substantive comments, please allow me to thank Madam Justice Wade Miller and the members of the Commission for having retained me as Commission Counsel. I'm very much aware that the subject of your inquiry is the culmination of many years of angst and concern among Bermudians that may have lost lands that rightfully belong to them without appropriate record or remedy or compensation. Equally importantly, I'm conscious of the fact that this commission is to meet the trust and expectations of the community. Then it must examine the past with a view of looking forward and make recommendations to the government of Bermuda that, if acted upon, will ensure that past injustices this commission may find will not occur again in the future. For the purposes of this morning, I wish to divide my comments into 5 parts. First, I shall deal with the legislative history leading to the Order in Council establishing this commission. Second, I want to say something about commissions of inquiry. Third, I will enlarge on what Justice Wade Miller already said and deal with the scope of this commission's mandate. Fourth, I want to review a 30,000 feet summary of the types of cases that would have to come before this commission. And finally, yet again mirroring the words of Justice Wade Miller, I want to review very briefly the work of the commission to date and next steps. Let me then start with the legislative history leading to the Order in Council establishing this commission. In 2014, the late Honorable Walton Brown proposed a motion which can be found in Hansard, pages 2014, pages 2603 to 2650, as follows, quote, that this Honorable House takes note of the historic losses in Bermuda of citizens' property through theft of property, dispossession of property, and adverse possession claims, and be it resolved that this Honorable House calls on His Excellency, the Governor, to establish a commission of inquiry into all such known claims and determine, where possible, the viability of any such claims and make recommendations for any victims of wrongful action to receive compensation and justice. The motion was adopted after considerable debate. What is important to present purposes, that it appears from the debate that while members were keenly aware of the concerns relating to Tuckerstown and the St. David's Island expropriations, the concern relating to injustices in dealings in land ran much broader. To give you but one example of the speeches, the Honorable Derek Burgess, Senior, at page 2637, Mr. Speaker, and I quote, the courts have made some blunders here taking people's land. When a man has paid taxes on his property all this time, and the court says, oh, I'm going to give it to the squatter, how foolish is that? As has been said on the other side by the Attorney General, that has to be tested. But why? When people cannot afford to test it, to take it to other jurisdictions, like the Privy Council, and they lose out, you do not get any. Poor people do not get any justice in this country, Mr. Speaker. The then Attorney General, in reply, made the point at page 2612, the Honorable Trevor G. Moniz, that probably 1980s, I think, 1980s, sharp practice is not something that's going to disappear. It is part of human nature. So I think we need to separate these two lots of cases. The compulsory purchase ones are largely older ones. The most recent ones are perhaps the ones dealing with St. David's that were done during and before the Second World War, when the airport was created in St. David's. Those were the most recent ones. And my own view is that there is nothing that we can do about it. What was done there was not, in my view, unlawful. The laws permitted it. Parliamentarians who made those decisions had their reasons for doing it. With respect to individual cases, the people that the honorable member said were taken advantage of, those really have to be dealt with on a case-by-case basis. Some of those are sort of apocryphal from the member because he did not name names. I'm trying to figure out, and I know a lot of cases where allegations have been made. And in a lot of cases, the allegations cannot be proved. They cannot be substantiated. They are not substantiated, and we get this, as a lawyer, I get this. Clearly, therefore, the intent of the motion was to explore takings of land, both related to Tuckerstown and St. David's Island and beyond, dealing with other cases of perceived injustices. The motion carried, but the governor of the day refused to issue an order establishing the commission. And there the matter stood, at least until the current order was issued in 2019. In 2019, the matter of a commission into historical losses was revisited. By this time, the 2014 opposition formed a majority government. The resolution reciting the earlier motion before the legislature was passed. And I will not repeat the words of the motion yet again. Madam Justice Wade Miller already stated them, although I shall return to the words of the motion because there are significant differences between the motion in 2014 and the motion adopted in 2019, which has significant, in my submission, legal consequences. I then want to deal with briefly, what is a commission of inquiry? When we received applications for standing, it became abundantly obvious that many thought that a commission of inquiry is akin to a court of law. I think I need to address that, and I shall do that by discussing broadly the nature of commissions of inquiry. Professor Ledane, who was later a judge of the Supreme Court of Canada, our highest court, we abolished appeals to the Privy Council. So we stopped with the Supreme Court of Canada. Had this to say about commissions of inquiry, and the full article can be found, Gerald, Jourdain, The Role of Public Inquiry in Our Constitutional System, Law and Social Change, 1973. A commission has certain things to say to government, but it also has an effect of perceptions, attitudes, and behavior. Its general way of looking at things is probably more important in the long run than its specific recommendations. It is the general approach towards a social problem that determines the way in which society responds to it. There's much more than law and governmental action involved in the societal response to a problem. The attitudes and responses of individuals at various places at which they affect the problem are of profound importance. What gives an inquiry of this kind its social function is that it becomes, whether it likes it or not, part of this ongoing social process. There's action and interaction. Thus, this instrument, supposedly merely an extension of Parliament, may have a dimension which passes beyond the political process into the societal sphere. The phenomenon is changing even while the inquiry is in progress. The decision to institute an inquiry of this kind is a decision not only to release an investigative technique, but to form a social influence as well. There are also good policy reasons why commissions of inquiry are not assuming the role of a surrogate court. First, its decisions are not enforceable at the hands of any single person or corporation. Indeed, to suggest that a party has a good case against another would raise unreasonable expectations without the clout of enforceability. Further, civil litigation is circumscribed by procedural rules, rules of evidence, and centuries built-in protections, all to ensure that to the extent possible, justice is done between the parties. None of those procedural or evidentiary protections are available before a commission of inquiry. Indeed, the very fact that the commission may submit by a certain time all but ensures that the case cannot be investigated to its fullest. Third, the conclusions of an inquiry cannot be appealed. The recommendations of the Commission may be accepted by the government or rejected. Such is not the case if a court issues a judgment. It is enforceable until set aside by a higher court. Finally, to accept the role of court will undermine the legitimacy of Bermuda courts and possibly lead to results that are inconsistent with judicial decisions. As said by Mr. Justice Binney in the Supreme Court of Canada in a case called Consortium Development versus Sarnia, the city of Sarnia, and I quote, "A commission of inquiry is neither a criminal nor a civil action for the determination of liability. It cannot establish either criminal culpability or civil responsibility for damages. Rather, an inquiry is an investigation into an issue, event, or series of events. The findings of a commissioner relating to that investigation are simply findings of fact and statements of opinion reached by the commissioner at the end of the inquiry. They are unconnected to normal legal criteria. They are based upon and flow from a procedure which is not bound by the evidentiary or procedural rules of a courtroom. There are no legal consequences attached to the determination of a commissioner. They are not enforceable and do not bind courts considering the same subject matter. So, to emphasize, Bermudians should not expect a judgment or a check or an order returning land or other property at the conclusion of this inquiry. That is not, I respectfully submit, is the role of this inquiry, as it is amply demonstrated by all of the jurisprudence that I'm aware of. Let me then deal with another aspect of the inquiry, which is very important, and that is fairness. One of the guiding principles of this commission is that it will ensure fairness to those who may be affected by its findings and recommendations. The principle, which is a cornerstone of our common law, is well summarized again by the Supreme Court of Canada in an inquiry relating to the blood system. We had an unfortunate situation where our blood collection system became infected with HIV, and many people became sick and many died. The late Mr. Justice Corey, the inquiry's roles of investigation and education of the public are of great importance. Yet those roles should not be fulfilled at the expense of denial of the rights of those being investigated. The need for careful balancing was recognized by Mr. Justice DeCarey when he stated at paragraph 32, the search for truth does not excuse the violation of the rights of the individuals being investigated. This means that no matter how important the work of an inquiry may be, it cannot be achieved at the expense of fundamental right of each citizen to be treated fairly. A commission is required to give parties a notice warning of potential findings of misconduct which may be made against them in the final report. As long as the notices are issued in confidence to the party receiving them, they should not be subject to a strict degree of scrutiny as the formal findings. This is because the purpose of issuing notices is to allow parties to prepare for or respond to any possible findings of misconduct which may be made against them. Therefore, in fairness to witnesses or parties who may be subject to findings of misconduct, notices should be as detailed as possible. Even if the content of the notice appears to amount to a finding that would exceed the jurisdiction of the commissioner, that doesn't mean that the final publicized findings will do so. It must be assumed, unless the final report demonstrates otherwise, that the commissioners will not exceed their jurisdiction. The Bermuda Commissions of Inquiry Act of 1935 does not set out the standard to be applied when determining when or whether a notice ought to be issued. However, in my view, keeping in mind the common law relating to fairness, that provision is to be read into the provisions of the Inquiry Act. As Commission Counsel, as the Commission is, I know, I'm committed that these principles committed to these principles, and that our process ensures that the Commission's proceedings will be fair. And therefore, if it becomes evident during the evidentiary phase that evidence about to be led may affect the fiscal or reputational interests of any person, then they will be served with a notice and invited to participate in person or through counsel in that phase of the hearings of the Commission. This is arduous work to go through the proposed evidence, and I've asked Mr. Bruce One, my co-counsel, to review the evidence prior to it being led, keeping very much at heart what I've just said, and ensure that anyone who may be affected by the evidence or by the findings of this Commission will be given adequate notice. The reality is that this is a public inquiry, and once their reputation is damaged, it is very, very difficult to reestablish that reputation that has been harmed by some careless or unintended comment by witnesses. Let me then turn to the scope of this Commission's mandate. As I noted earlier, there are some significant differences between the motion adopted in 2014 and the motion adopted in 2019, which led to the order in council. Although the preamble, the scope of the inquiry, recites the motion passed in 2014, it is significant that what the inquiry is to do does not mirror what was said earlier. You do not find the words, quote, "The Commission may make recommendations for any victims of wrongful action to receive compensation and justice." Those words are significantly omitted from the order in council actually establishing this Commission.
Come on, man.
And therefore, yet again I submit that the legislature, when creating this Commission, did not set up this Commission as an arbiter of civil liability. It only has the power to make recommendations to the government, and they're very specific. In addition, and I think it's important that the Commission has the power to make recommendations to refer cases to the Director of Public Prosecutions. In other words, yet again, it's not up to the Commission to make a determination of criminal culpability, but rather the Commission is to refer the case, if there is some suspicion, to the DPP, the Director of Public Prosecutions. In my submission, once you take the context of the current order in council, particularly the context in which the words I found, the word historic signifies both a temporal inquiry and as well as looking for a systemic injury. And therefore the Commission should determine, through the lens of the cases that have been filed before the Commission, and based on the evidence it is about to hear, whether the evidence taken as a whole demonstrates a historical structural problem or systemic failure, and identify the lands were historically lost by reason of theft, unlawful or irregular dispossession, unlawful or irregular adverse possession, or other unlawful or irregular means. Let me say a word about what do I mean by systemic issues. And I say that because this question has been raised by a number of commissioners in our past deliberations. And I can do no better than illustrate the point by referring to some decided cases. In one case, dealing with a medical malpractice case, the court says this: the claims advanced on or behalf of all members of the proposed class, this was a class action, whether in tort, breach, or contract, or breach of fiduciary duties, are founded at least in part of allegations that Dr. Menon, a chief of pathology, director of clinical laboratory services, an on-site pathologist, allowed a pathology department and laboratory function for many years without the systems necessary for the safe operations. These systems would have included appropriate quality assurance and quality control programs. It is alleged that the systemic failures allowed Dr. Menon's substandard work to go undetected or unremedied for years. In other words, what we are dealing with is not the actual negligence of Dr. Menon, but rather the structural problems or the systems that were in place to detect negligence. And there's a distinction. Similarly, in the case against the Bank of Montreal, Nesbitt Burns, while the proposed amendments will increase the scope and complexity of the discovery process, the additional facts are relevant and are potentially probative of the negligence as part of an alleged systemic failure of supervisory and compliance systems. So again, the focus is on the structure rather than on the actual negligence. Let me then turn to a brief summary of the type of cases that the Commission has jurisdiction to consider. The first words of the mandate are theft. And I will simply refer you to Section 331 of the Criminal Code of Bermuda, 1905. And I'm not going to read it in its fullest, but broadly, a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it, and thief and steal shall be construed accordingly. It is immaterial whether the appropriation is made with a view to gain or made for the theft own benefit. It then defines what is dishonesty, and we may have a discussion as we go along as whether or not a particular allegation falls within the definition of theft. But in my respectful submission, at the end of the day, in considering whether a matter should be referred to the Director of Public Prosecution, you will have to keep in mind the provisions of your criminal code. Now, the next heading is loss of property by dispossession. I pause there because you will recall that the phrase is actually carries on or adverse possession or other unlawful or irregular means. As I read the whole of the phrase, the words unlawful or irregular means modify the words that precede them, and therefore loss of property by dispossession also must be by unlawful or irregular means. Much will depend on the context of the particular cases. But, for example, and I will turn to expropriation cases in a minute, where, for example, land was expropriated without adequate compensation, that may well be at least irregular, if not unlawful. And I will have more to say about expropriation in a minute. Now, loss of property by adverse possession. And I think in order to consider that, you need to understand what is adverse possession. In Lord Advocate versus Lord Lovett, 1885 appeal cases, 273, Lord Atkin has this to say. In the Barr versus Shea, 1873, 29 Law Times, 592, Sir Montague Smith, delivering the judgment of the Judicial Committee, said at page 595, the result appears to be that possession is adverse for the purposes of limitation when the actual possession is found to exist under circumstances which evidences incompatibility with a freehold in the claimant. This was explained in a case called Newfoundland versus Collingwood in the Court of Appeal of Newfoundland by Madam Justice Cameron. One of the principles underlying the law relating to limitation of actions in respect of realty is the squatter claiming adverse possession must prove open, exclusive, notorious, and continuous possession. The law is that the nature of the possession must be considered in light of the circumstances of each case. In our submission, however, this commission is not required to resolve title issues. That is for the courts. Rather, as I said a minute ago, the order in council modifies adverse possession by other unlawful or irregular means by which land was lost in Bermuda. On the face of it, this seems inconsistent with the concept of adverse possession, since the very purpose of adverse possession is to protect the rights of the squatter. It's a limitation issue. However, when you consider that the words actually modify the words adverse possession, the issue then becomes, in my submission, how the squatter became a squatter. Did the squatter become a squatter by some unlawful or irregular means? And if so, you may have view on the point. In other words, you are not to resolve the title as between the squatter and the owner of the deed, but rather you are to examine how the squatting, if I can use that word, came about. Did the squatter become a squatter by unlawful or irregular means? Let me then turn to the last phrase, loss of property by unlawful or irregular means by which land was lost in Bermuda. And I also think, as I mentioned earlier, that this is also included in dispossession of property. But specifically, I want to deal with expropriation cases. In my respectful submission, the Commission will have to examine the expropriations from two perspectives. Namely, was the dispossession unlawful? And second, even if on the face of it, it was lawful, was it done, was the legislation passed irregular? And was the dispossession itself irregular? In the leading case, in Attorney General versus the Kaiser Royal Hotel Limited, 1920 appeal cases, 508, House of Lords, Lord Atkinson at page 542 put the rule in his own words and followed with a quotation from Lord Justice Bowen. This is what Lord Atkinson said. The recognized rule for construction of statutes is that unless the words of the statute clearly so demand, a statute is not to be construed so as to take away the property of a subject without compensation. Lord Justice Bowen, in London and Northwestern Railway Company versus Evans, said, the legislature cannot fairly be supposed to intend, in the absence of clear words showing such intention, that one man's property shall be confiscated for the benefit of others or for the public, without any compensation being provided for him in respect of what is taken compulsorily from him. Parliament, in its omnipotence, can, of course, override or disregard this ordinary principle if it sees fit to do so. But it is not likely it will be found disregarding it without plain expression of such purpose. In the same case, Lord Parmoor, at page 579, put the rule this way. I think that there is no difficulty in applying the ordinary rules of construction, but if there is room for ambiguity, the principle is established that, in the absence of words clearly indicating such an intention, the property of one subject shall not be taken without compensation for the benefit of others or the public. As part of its recommendations, this Commission will have to consider all the circumstances relating to the two expropriations, their illegalities, whether or not they were passed regularly, and make appropriate recommendations to the government of Bermuda. For example, if this Commission concludes that owners of property were not compensated adequately by reason of the system of compensation set up by the government, it may recommend that the government in the future that a different regime should be set up in case of expropriations, as well as to recommend that by reason of the circumstances that led to the expropriation in the instant case, the government should set up a regime to compensate the owners or descendants of the owners of the expropriated property. In other words, this Commission cannot issue an order to compensate, but it may make a recommendation to the government, which the government may accept or reject, to set up a regime and examine individual cases whether adequate compensation was paid. This is not the time for submissions as to what should be the proper heads of compensation. That will come at a later day. But as a general principle, in my opinion, that recommendation is available to this Commission. And in saying what I said, let me emphasize yet again, and I quote yet again, Mr. Justice Binney, it must be remembered that the report of the Commissioner to the City Council will respect only his views and will not determine civil or criminal liability of any. In other words, your recommendations do not determine liability. It's a recommendation. Let me finally turn to the work of the Commission to date and the next steps. And I think I can be rather brief because Madam Justice Wade Miller has preempted me and said everything that I could say and much better. Suffice to say that unforeseen events that no one could have foreseen as of last January interfered with the work of this Commission in a very, very substantial way. Borders were closed, and you will recall I had, and I still do, had plane tickets to come to Bermuda for March 19. The very day I was about to board the plane, the government of the USA closed its borders, and the government of Canada advised that the citizens of Canada must return to Canada forthwith. I was at that time actually located in the United States. So my work was interfered with. I couldn't come to Bermuda. I still cannot because we are still under a travel advisory. And the way the world is unfolding, it seems like with the return to school, we may well have an increased amount of problem. In any event, because of that, matters got delayed both in the Commission's work, the experts' work. Witnesses were not as readily available as they would have been otherwise because there was a lockdown. As I'm looking at you, you're still wearing face masks. I don't have to because I'm by myself. Unfortunately, this pandemic interfered, and I regret to say will continue to interfere with the work of this Commission. However, we are soldiering on. We are starting today with the first of our witnesses, and she will provide, based on her own research, and I had occasion to review her documents, very extensive research, if I may say, some historical background to this St. David Islands appropriation. She was but a child at the time of the expropriations, but she read a lot about it. And that will be the extent of the evidence I, as Commission Counsel, will offer as of today. We shall return on October 19, and I'm very much hope we have a commitment, and I'm very much hoping that I will have the historian's report well in advance so as to be able to meet my commitment to give meaningful notice to those who may be affected by the historian's report in sufficient time for them to respond. Likewise, to the extent the evidence today was not available until rather recently, I undertake that the transcript from today's evidence will be made available to those who may be affected by it. So with that, Madam Justice Wade Miller, I'm closing my opening remarks. Again, thank you for the opportunity for being here. I'm sure it's much more pleasant in Bermuda as we speak than it is up here. We are having a bit of an early fall, but so be it. Thank you very much.
Thank you, Counsel. I am going to ask commissioners to take a health break for perhaps 15 minutes, and then we'll hear from our first witness. Thank you.